Okay, sorry about that.
All kinds of technical difficulties.
I know. Assalamu alaikum everyone, my name is Arid Sayyed. I'm a local attorney here in Princeton, practicing wills and estates, real estate law, family law, and civil litigation. I wanted to prepare an Islamic wills presentation for everyone because I always get questions about Islamic wills. Not a lot of people know about them, not a lot of people know that you can get Islamic wills in New Jersey, or what even the difference is between an Islamic will and a regular will. In addition to that, I'll be discussing trust as well, which is a great vehicle for people to protect their assets and keep them out of the hands of the government. So this is going to be an overview of our presentation, details regarding wills, how to get started, the probate process with the government, and an overview of trust. Now, I wanted to start my presentation with a quote from the great Allama Iqbal. In his foreword to Shikwa, Jawabit Shikwa, he dedicated this seminal work, stating, "Dedicated to my future generations, because my migration, resulting in their having to spend their lives in an environment remote from their ancestral language and culture." Now, this can ring true with a lot of us here. We're all immigrants, children of immigrants, and truly all of us Muslims here in America are muhajir as well, just like Allama Iqbal was. And we came to this country to give a better life for our future generations. And alhamdulillah, we can look at this beautiful masjid. We have succeeded. Many of us have succeeded in this country beyond our ancestors' wildest dreams. Now, our children, on the other hand, have to live in a country where it's not an Islamic country. People don't understand their cultures. But we can give them something our ancestors didn't. But are we making sure everything we've earned in this country is going to be passed down to our beneficiaries, our children? Are we going to be able to give our children their haqq, which they're entitled to according to the Quran? Now, the importance of having a will in Islam. In Sahih al-Bukhari is written, "It is a duty of a Muslim who has anything to bequeath not to let 2 nights pass without including it in his will." Now, estate planning can be very difficult, and people don't want to think about the unknown. People don't want to think about, what's going to happen when I die. They want to think about tomorrow, that's it. But it's very important that we think about this because tomorrow is not promised to us. And we want to make sure that everything we've worked for in our lives is going to pass to our children, our parents, our spouses, and all our beneficiaries as enumerated in the Quran. So what is a will? It's also known as a last will and testament, and it's a legal document specifying how your estate or your property is to be divided after your death. Wills allow you to name an executor and designate a guardian for your children if they're minors. It also allows you to name a trusted person to care for property left for your children. Now, there's many challenges if you pass away without a will, which is what is called passing away intestate in the state of New Jersey. There can be wrestling for control of certain assets by your heirs, wading through lengthy court delays, and paying a larger tax penalty than necessary. Now, people also ask, what is a living will? How is it different from a last will and testament? A living will is a document that takes into effect when you're incapacitated or you have an injury where you might be in a coma, you can't make decisions for yourself. But what's going to happen with your finances? Who's going to pay the mortgage on your house? Who's going to pay the electricity bill? So a last will and testament only comes into place when you pass away. But if you have living will documents like a healthcare power of attorney and a financial power of attorney, you can elect someone in the case you can't make decisions for yourselves to make those decisions for you. A healthcare power of attorney will allow somebody to make medical decisions for you, which is very important. A financial power of attorney will allow an agent to act in your place and manage all your personal and business affairs. This might mean selling your property to pay for your medical bills. This might mean paying for your car so it doesn't get liquidated. These are very important things we have to think about because our finances are not just going to pass when we pass away, but if something happened to us and we can't make our decisions for ourselves, we need to make sure somebody is there who has the power to make those decisions for you. Now, Sharia-compliant wills. In addition to abiding by secular laws of the United States, a Sharia-compliant will abide by the laws enumerated by Allah subhanahu wa ta'ala in the Quran. The Quran is the primary source for Islamic inheritance laws, specifically Surah An-Nisa, chapter 10 through 14. And of course, many scholars have written about wills in detail, about what happens in different circumstances. What you need to know is before any division is made, your will needs to make sure that the cost of your funeral is taken out of your estate first, according to Islam, that any loans or debts that you owe are paid out as well. Furthermore, when you pass away, a lot of people don't think about this, but you still owe zakat. So you want to make sure in your will it has a provision, your executor knows that the day of passing, calculate that according to the last Ramadan, you need to figure out how much zakat is owed, and that needs to be paid out of your estate before anything is distributed to your heirs. After that, you can bequeath up to 1/3 to charity. The remainder or residuary has to pass to specific beneficiaries. I'm not going to go into much detail, but simply the husband receives 1/2 of the estate or 1/4 if there's children. Wife receives 1/4 of the estate or 1/8 if there's children. Parents must receive 1/6 each. Each parent has to inherit under your will as well. Then the remainder, it goes to your children, and it follows a 2-to-1 ratio for sons and daughters. Now, there could also be secondary beneficiaries. When I craft wills, there's a lot of math involved, a lot of fractions. Sometimes there's a little bit of a remainder. Some of your secondary beneficiaries could be your brother, sister. It goes on from there. Now, when you want to prepare your will, you want to write down everything that you have and make a rough valuation of your estate. You also want to detail how you want your funeral and burial arrangements to be carried out. You don't want to leave this in the hands of your grieving wife, your grieving children. You should state explicitly, I want to be buried here. I want my janazah to be performed here. I want this service to perform the wudu over me. Even if you have wishes about who you want to do the wudu over you, put it in your last will and testament. Why not? Why leave it up guesswork to anybody else? You also want to be thinking about a guardian and trustee for your minor children. This is very important. If you pass away and you have minor children, God forbid you and your wife pass away at the same time, the state is going to come and take your children and place them in foster care until they figure out who should have guardianship over your children. This could mean your children are placed with strangers, non-Muslims, houses where nobody's praying salah, nobody's eating halal. It's very important for Muslims to make sure, speak to your family members, speak to your friends, have a guardian elected for your minor children. There's really no reason not to have this. There's also, you want to have a trustee for your minor children. So anybody under the age of 18 cannot inherit legally. They have to wait until they turn 18 to inherit. So you want to make sure you elect a trusted person as the trustee to hold this money as an amanat for your children and give it to them when they turn 18. They can invest that money and have that further income going to your children. They can give them a small portion when they turn 18 if you don't want your children to receive large amounts of money when they turn that age, and give it to them as a step program, whatever you want to happen, but you need to enumerate this in your will. In New Jersey, you must sign your own will, and it has to be witnessed and signed by 2 other people over the age of 18. It also needs to be an original will. When you probate your will, you have to make sure it's the original one, or you're going to get a headache from the probate court, okay? That's why I advise sign your wills in blue ink, keep the original, and make sure your executor knows where the original is kept. Notarization is not required by the state of New Jersey, but it does help speed up the process. What I do is I craft a self-authenticating document to my wills, which you again sign, 2 witnesses sign, and then either myself as your attorney or a notary public signs. This is going to speed up the probate process when you go through the government. You can also choose to register your will with the state of New Jersey for a small fee. Honestly, I think this does nothing. It's not going to speed up the probate process. The government is going to collect a small fee from you, and it's not going to make anything any faster. Now, very important, your will is actually not filed until you pass away. After your death, your executor needs to wait 10 days, take your original will and a certified copy of your death certificate, and file that in the surrogate court in the county in which you last resided. You can update your will as well. You don't need to make a completely new will. You update your will by drafting a document called a codicil. It's basically, you sign it, two witnesses sign it, and you state explicitly what changes you want to make. Now, anytime you have a significant life change, like change in marital status, having children, if an heir or an executor passes away, or you move to a new state, because certain states have requirements that if you're having a notary sign it, it has to be a notary from that state. Now, what happens if you don't have a last will and testament? You're going to be die accordingly intestate, which means you have no say in the transfer of your wealth. The process would be similar where your heirs would go to the probate court, but how the state does it is they allow any and all heirs that could inherit to come forward, sign, give their information, and they're going to divide it equally between all your heirs, including parents, children, siblings. Now, if this happens, your estate is not going to be divided according to the Sharia because it has to be divided according to explicit fractions. And if they can't find a family member, the state's going to take all of your assets. Now, what is probate? Probate is the process that the government starts when you file your will with them after you pass away. It's a required and mandated process, and it's essentially a way of verifying your witnesses say who they say they are and that you actually intended to sign this will. This process can take months, even up to years sometimes. That's why you want to make sure you have your original will and you draft a self-authenticating document either signed by an attorney or a notary public. This is going to speed up the probate process because essentially an attorney, an officer of the court saying, I witnessed these witnesses saying who they say they are. Now, we're going to talk about the executor under your will, a very, very important position. Not only does your executor file your will for you, your executor is going to get the power from the government to actually divide your assets and make sure your assets are divided as stated in your will. Now, many times people want to elect their spouse or their children as their executor. I highly advise against this. One, you don't want to have a grieving spouse, a grieving child having to go through the court process to get all of this done at the time of your death. Number two is it can lead to conflicts of interest between your heirs. Now, we've all heard horror stories when somebody passes away, children are fighting amongst each other, I want this asset, I want this asset. No, maybe there's a spouse that nobody's thinking about, what's going to happen. You want to make sure the person who has the power to divide your estate is also not inheriting under your estate, because then nobody can claim a conflict of interest or a bias. Because sometimes you might need to sell your assets to make sure your heirs inherit. Sometimes people don't want assets sold. Sometimes somebody wants a certain asset, somebody else wants another asset. Make sure your executor is a third party. Now, your executor is going to inventory everything and collect your assets and essentially make a valuation of your estate. Because Islamically, some people are getting 1/6, some people are getting 1/4, 1/8. The rest is being divided 2-to-1. You're going to want to create a value of your entire estate, figure out how much each of your heirs is entitled to. Then after that, there's many things you can do. You can give somebody cash out. If you don't want to sell your house, if you want one person to have your house, you can give your other heirs the value through cash. Or you can list numerous heirs on a deed. So your executor would sign a deed, transferring the interest from you over to your heirs. You put your numerous heirs as the beneficiaries, and explicitly on your affidavit of title and your deed, you want to state how much each person's interest is. Now we want to talk about trusts. The will is a public document, right? It gets filed with the government. The government has a say. If the government is owed any taxes, if your creditors are owed taxes, they're going to be able to go after your estate. Especially, a lot of people don't realize this, If you're receiving Medicaid benefits through the state after the age of 55, any benefit that you receive, the state makes an accounting of that, and they're going to collect every single penny from your estate after you pass away. So another thing I would like to say, if you plan on going on Medicaid, to receive those benefits, and there are a lot of great benefits from Medicaid, you want to make sure your estate is planned in a way before you start Medicaid. You might want to transfer assets beforehand, because once you get on Medicaid, even if you transfer assets over, like let's say you sign your house over, the government will be able to go after the person who you assigned your house to and collect everything they paid out through Medicaid. Now, a trust is different. A trust is a completely private document. The government never gets involved. It's a legal structure that allows you to manage your assets while you're alive and pass your assets to your beneficiaries when you die, rather than going through the courts. So you're not going to have to go through that probate process. You can think of it like an imaginary legal entity that you fund with assets. This will give you a lot more control over how your assets are distributed after you die, and you get to decide who gets which assets, how much, and when they get access to them. Now, this is really important. Let's say you have some children, and we all know our children these days, maybe they might be the most responsible with money. If you want to wait for a child to inherit your entire estate, if you're worried they're going to deplete your assets after you pass away, the trust allows you to have a trustee who's going to manage over your assets, and they'll have the control over your assets while your children will be the beneficiaries of your assets. So while a trust and a will both let you designate beneficiaries, a living trust allows you to choose your trustee to manage your assets if you're ever incapacitated as well. This could also further potentially avoid the need for having a financial power of attorney. Now, there's three roles in a trust. There's the grantor, the trustee, and the beneficiary. You are the grantor of your own trust. So let's say your name is Arid Sayyid. You would draft a trust, and it would be called the Trust of Arid Sayyid. You would be the grantor of that trust. You would also be the trustee and the beneficiary while you're alive. What would happen is, after you pass away, either one of your heirs, all of your heirs serving together as a board, or a third party could act as the trustee to manage over your assets, and then your heirs would become your beneficiaries. So, for example, let's say I own one house worth $100,000, okay? I have 4 children when I pass away, 3 girls, 1 boy, and I have a wife. We can do the standard Sharia division, and what would happen is when you sign your trust, you will fund it with an asset. So let's say you have a house, you'll craft a deed transferring the ownership from yourself over to your trust. Now, technically, your beneficiaries already have an interest in that house the moment you put it into the trust, but it's a future interest conditioned precedent on you passing away. Now, this is great because the second you pass away, that trustee can say, well, I don't have to go to the government. I have the power to do whatever I need to do with this house to get this money to the children and the wife. So what they can do is they can either do nothing, and the house will automatically be owned by your children and your wife and whoever else is your beneficiary according to their Sharia interest, or the trustee can sell that house and disperse the value of that house accordingly. You won't have to wait for letters of administration. You won't have to wait through probate court. You can do this automatically, and the government stays out of it. If you have numerous assets, I highly advise getting a trust because your division can get complicated if you have a lot of different assets. Let's say you have numerous houses. Are you going to craft deeds for each of those houses, split those interests, for each of those houses separately? You have a trust, your children will have an interest in all of them automatically. Now, I already went over to create a trust. You have the grantor, the trustee, and the beneficiary. And after you pass away, then this will come into effect for all your beneficiaries. Then we'll fund the trust. You can fund the trust with a house. You can put your car in a trust. Many times you have to retitle the asset. Contact the financial institution for the associated asset. So you can contact your bank. They'll help you put your bank account into a trust. If you have stocks, a brokerage account, they'll help you put that into a trust as well. Now, many times all you need is a simple form to fund the trust. For real estate assets, you need to craft a deed, affidavit of title, file that with the county. You can always move assets into your trust and remove them out of your trust as well. And this is not going to trigger any tax penalties either. So you're going to ask, what assets belong in a trust? Liquid accounts like bank accounts, traditional investments, not retirement accounts, real estate, intellectual property, money that you're owed as well. If somebody owes you a debt, you write that into your trust. So when that debt is paid, it'll go to your beneficiaries through the trust. And safe deposit boxes as well. Assets that don't belong in the trust include retirement plans and accounts because they're going to have a stated beneficiary on them already. Similarly, tax advantage savings accounts, life insurance, they're all going to have beneficiaries on them as well. Technically, you can change the beneficiary for all of these to the trust. You can do that, but if you don't do that, they cannot be funded into your trust. So the bottom line is the trust is a great way to manage your assets while you're healthy and ensure that they're distributed as you intend. However, while plenty of your assets work beautifully in a trust, it's not right for everything you own. At the end of the day, what's important is that your individual's assets go to whom you want them to go to and when you want them to get them. You don't want to be waiting for the government to, giving you permission to transfer these assets over. If you choose to have a will, definitely make sure you have a self-authenticating document to avoid all that. But for many people, a will will be sufficient as well. Let's say you have one house, not a ton of assets, a will is fine. If you have multiple assets and a lot of heirs, you definitely want to be thinking about a living revocable trust. If you need help with your Islamic will, please feel free to contact me. You can grab a copy of my estate planning checklist outside before you leave, and you can download my free ebook, A Guide to Estate Planning, on my website, aridsayyidlaw/resources. And for the rest of the time, I just want to open it up for any questions anybody might have. Yes, sir? So it depends. You can technically put your kid's name onto your deed while you live as well. If you want to hand that over to them, they'll have equal legal title to them. So if you want to sell that property, your kids will need to agree as well. That's one way of doing it as well. There'll still be some tax penalties. If you want to avoid taxes, trust is the way to go over a will. New Jersey is not so bad with the inheritance taxes, but if we're talking about millions of dollars, you certainly want to have a trust. Once it's in trust, it stays out of the government's hands, right? So there's going to be no tax penalty for you to transfer that asset over into the trust. And then from the trust to your beneficiaries, there's going to be no tax. Because if you think about it this way, they're technically not inheriting it. They're getting it when you transfer it into the trust, but their interest starts the second you pass away. This is a legal scheme created in America by the rich and powerful. This is what people who have money do in this country to avoid taxation. So if you're worried about taxes, you definitely want to thinking about a living, revocable trust. Yes, sir?
Could you go over again, you had a slide up there about Sharia interest, and you said an eighth, a quarter, et cetera. Can you explain that aspect?
Absolutely. So let me see if I can go back to that slide. Here we go. Feel free to take a photo of this, and of course, you can call me and we can discuss all of this, but you actually find all of this in Surah An-Nisa, ayahs 10 to 14 as well. And it's very important. So if you're a man, if your wife passes away, you will inherit either 1/4 or 1/8 if there's children involved. But if, let's say, a man passes away, the wife will inherit, the husband will inherit 1/2 or 1/4. The wife will inherit 1/4 or 1/8. Now, a lot of times this is a little bit controversial in modern times in America. People ask, why is there a difference between male inheritance and female inheritance? But we also have to remember, this is because as men, we have an obligation to provide for the women in our lives. Very, very important. That's a Sharia compliant obligation as well. We have to take care of our mothers. We have to take care of, our sisters. That's why a man will inherit twice what a woman will inherit according to the Sharia.
So in products that are invested in this country, right, typically they have the beneficiaries.
Correct.
Typical fashion is the wife and then the kids, right? How does this interrelate? Or by putting everything in a trust, do we automatically go this way? Is that what happens?
This is a great question. So, right, when you invest, you will have stated beneficiaries on your 401k. There'll be stated beneficiaries who is supposed to get all this money. Now, what you want to do is you create the trust, and then you change your beneficiary to your trust. And that way, that trust will get all those benefits, and then those trusts already has the stated beneficiaries in there. That way, your 401k, it'll be able to pass to everybody. Because you raise a very interesting question, right? Because our stock assets are assets as well. Many times they're our most valuable assets. So when we think about us, Allah subhanahu wa ta'ala giving us the obligation of, passing our estate to our children, if our stocks are going to one person, let's say the spouse, this is the usual beneficiary, technically, is your estate being divided Sharia? I don't know, because as the stated beneficiary is also according to a contract law, they are the stated beneficiary. But I believe it's a lot fairer if you put it into the trust as the beneficiary of those assets, then everybody's going to be able to get that divided portion from them. Exactly, absolutely. So what you're going to do is you will have your trust, and in your trust you would state, oh, my husband receives this, my parents receive this, my children receive this, and then on your 401k, change the beneficiary to the trust.
So Jersey will not have a problem.
Not at all. Yes, sir?
You keep your spouse, for example, as the primary beneficiary of your IRA or like 401k. Can you then say in your will that the wife is obligated to distribute that asset according to the will?
You cannot make that change according to the will. It has to be changed on those 401k documents. So you can't say that, oh, this is my 401k, but I wanted to go to my wife instead. New Jersey is not going to honor it, and the 401k, whoever that brokerage is through, they're not going to honor that either.
No, what I mean, in your account, the primary beneficiary is your wife, right?
Correct.
Then in your will you say, I want my wife to distribute what she gets from my 401k as 1, 2, 3.
Yes, you can do that. So wills can get as creative as you need them to get. So let's say you have your entire estate is, $100,000, your house is worth $50,000, your stock account is worth $25,000, and then you have cash in hand, $25,000. You can state that, well, my wife is getting the beneficiary from my stock accounts. She's going to get this amount of money. It becomes a little bit difficult because that valuation is going to have to be made by your executor. So that's why you want to, if you're getting creative with your estate like that, you want to make sure your executor is somebody who's going to be competent enough to make the valuations for your stocks accounts. Make sure they know that, all right, the wife is going to get this much money from the stock account, then I have to evaluate however much she gets according to the rest of the estate. Now, a problem arises is, what if your spouse is a beneficiary of your stock accounts, but your stock accounts are so much that they're getting more than they're actually entitled to? In which case, it's going to create difficulty. That's why I suggest just have your trust as the beneficiary. Because let's say you have a lot of money in stocks, and that spouse is getting all that money in stocks, there might not be enough left over in your estate to fund the rest according to Sharia division. Which actually, sir, you actually brought up a very good point as well. In the state of New Jersey, there's a law called spousal election, and this is a law in many states in America where a spouse can choose to elect 50% of their spouse's estate when they pass away, automatically before division. Now, if this happens, your estate clearly is not going to be divided according to the Sharia. So what I do is craft waivers of spousal election. So when you're making your estate plan, you want to make sure your spouse signs a waiver that I'm going to waive my right to the secular division under the law of New Jersey State, and we want our estates to be divided what is in our will according to the Islamic tradition. Yes, sir?
Quick question, for instance, you create a trust and then you pass on all the transferable assets to the trust. What if the guarantor and the trustee, they both are deceased at some point, just hypothetical worst case scenario?
Right.
Then who gets to recruit or operate the trust?
So the grantor is going to be deceased because you're going to be the grantor, right? The trustee, so what you want to make sure is you have substitute trustees in your trust as well. Very important. So I give all my clients intake forms. You want to name a successor trustee, and I would advise have 2 successor trustees because you don't know what's going to happen in the future. Similarly, executors, you want to have 2 substitute executors as well. Same thing for guardian and a trustee under your will for minors as well, because you don't know what's going to happen. Even if that person's not passed away, if they're alive, they might be elderly, they might be incapacitated, they might not want the responsibility at that point. So you want to make sure to prepare for those contingencies and name people who are going to become the trustee. Now you may ask, all right, well, what if my trust survives, generations, right? My grandchildren are ultimately going to inherit my trust from their parents, right? Who's the trustee going to be? In that case, the beneficiaries will be able to vote who they want to elect as the trustee as well if they need a new trustee in place. That could be one of the beneficiaries. The beneficiaries can all say, all right, we'll make a board. There's 5 of us. We're all going to be able to make votes on what's going to happen. We'll manage this together. They can elect a third party. They can hire an attorney as well to make those decisions as well. But that's why the trust is a much more complicated document than the will, because there's many things that might happen, but you want to make sure your trust is very comprehensive and taking into account. I also advise people, put into your trust that maybe at a certain point, if I have a lot of assets, somebody needs to manage my assets, that trustee can be paid a small amount from my trust to do so. Because let's say your named trustees all pass away, nobody else wants to take this responsibility because it is a big responsibility. Sometimes you might have to put in there, well, we could allocate, for the person's time, however much time they're spending, they can be paid off of the trust assets as well to do that. Yes, sir? Exactly. So under a will, taxable events can be created, right? So if somebody is inheriting, New Jersey's a pretty good state. If your spouse, children are inheriting, even parents, they're not necessarily going to tax that. If you have a residuary, like a brother or a sibling, in certain circumstances that might inherit, that would be a taxable event. Unless we're talking about a lot of money, which in case your children could be subject to inheritance tax as well. That's why you want to create the trust. So the will can create taxable events, but the trust is going to avoid that. The only tax that can be created, from the trust is, let's say you have rental properties, and those rental properties are in the trust, and they're creating income. The income those rental properties in your trust create, you have to pay taxes on that, but the actual transfer to your beneficiaries in the trust, that's not going to be taxable. Even if it's, if you want to bequeath somebody else, let's say from 1/3, you have a poor family member who's not going to inherit, like a cousin, you want to include them as in part of your trust as a bequeathment, they're not going to be taxed either, as long as it's in the trust. If it's in a will, they're going to be taxed.
Are there other states where that would be a taxable event?
Yes, so each state has different tax laws. In certain states, there could be taxable events. I only practice in New Jersey, so I'm not sure, but that's correct. In other states, potentially, but not in a trust. The trust will protect you regardless of what state you're in. Yes, sir?
In case of absence of a will, who is the automatic inheritance in case of the spouses?
So in the absence of a will, it's going to be a complete mess. So one of your heirs is going to have to go to the government and file for letters of administration, which will give them power to distribute, but the government's going to want to know a list of all your heirs, who these heirs are, names, addresses, and they're all going to have to agree on one person to be the administrator, which can create conflict, as you can see. And then all the inheritors, they're going to share equally. So basically, the court is going to decide who's going to get and how much they're going to get. And what the court is going to do is look at how much your heirs are, and they're going to go, there's a first class of heirs, right, through the state, your spouse, children, and parents. They're all going to share equally, but then sometimes a brother might come into the play, a sister might come into play, a cousin might come into play. And they might apply and say, oh, well, no, but he told me that he wanted me to inherit and that he's always taken care of me. And the state's going to be like, well, I don't know. And they're going to take everybody's arguments into consideration as to who is exactly going to inherit. That's going to cause a lengthy court battle, could cause conflict of interest between your beneficiaries. And whoever the beneficiaries end up being, they're going to share in that estate equally, which is not according to the Sharia. No, the spouse is not. However, unless you have a waiver of spousal election, they can choose to take 50% of the estate right off the bat. Yes, sir?
Is there a minimum requirement to establish or maintain a trust?
There's no minimum requirement at all. And you can even put, your personal property into this trust. And indeed, if we think about it, the Sahabas, they didn't have mortgages, they didn't have million-dollar homes, they didn't have a ton of jewelry. What they were dividing was their personal effects, right? Their books, their clothing, things like that. And even those things need to be divided according to the Sharia, because this is all your estate, and this has value. And it's not just the value of money, but it's the value of, your children, your spouse, your parents getting something that you owned and it going to them instead of going to somebody else. That type of inherent, the love value for that. So there's no minimum amount. You can put into a trust sometimes. What some people do is, if the value of the trust goes below 50,000 or another number, a low number, that the trust can be dissolved and the money will be distributed. Many times people like to choose to keep the trust and instead of dividing it and dispersing the trust, because they want somebody to manage that as well. But if a value falls below a certain amount, you can choose to have, the trustee can choose to dissolve this, but there's no minimum requirement to make a trust. But I would advise, if you're talking about if you don't have a ton of assets, save yourself the money, get the will. A lot of attorneys are going to tell you, no, get a trust no matter what. If you don't have a ton of assets, right, just get a will. It's going to serve the same purpose. There might be a little bit longer going through probate, but if you have the self-authenticating document, it'll speed that up, and you won't have to spend the money on creating a trust. Yes, sir?
Islamically speaking, can you assign contingencies to the trust or the will? For example, children receiving at a certain age, or only if they marry within the faith, only if they are not converted.
So there are some conditions in Islam that you can put into your will. One important one is only a Muslim can inherit under your estate. If, let's say, you have a beneficiary that chooses to leave the faith, you cannot leave any part of your estate to them. And I put that in all my wills as well. Also, Islamically, God forbid this ever happens, if one of your beneficiaries murders you, they cannot inherit either. And I put that into the wills. Now, if a certain person marries outside the faith, it's not a condition that they cannot inherit. And the Quran is very, very serious about this. Our children might do certain things that we don't agree with. All parents know that children do this. There's only few events that's going to prevent them from inheriting. Even doing very bad things that I don't want to go into detail with, but under Islam that are sins, even if they're openly doing those sins, as long as they're a Muslim, they're still entitled to your estate. There's a few differences of opinions between the madhabs. What happens, let's say, a child is not a Muslim, and then after you pass away, they say, oh no, I'm a Muslim, I deserve part of my parents' estate. That's where you need to make sure you have an executor that's going to be able to take this responsibility very seriously and knows your family and be able to tell, is this person telling the truth or not? There's certain Hanafi opinions that say that if this person was not a Muslim, during your life before you passed away, they're not going to inherit. There's certain other opinions that say if they say La ilaha illallah after you pass away and say I'm a Muslim now, then they can inherit. There's differences of opinion. We're getting into really like specific fiqh opinions on that, but those are the two major things that I know of that will prevent somebody from passing away: murder and then leaving the faith. Yes, sir?
How much do you charge for will and how much for the trust? And together, like how much?
Excellent question. So for wills, if it's one person doing the will, my will package is $500. That includes the living will documents as well, the self-authenticating affidavit, and the waiver of spousal election. If a couple, husband and wife, choose to do a will together, I offer a discount, of course. It'll be $750 for each spouse will have a will, living will documents if they choose. Also an advanced healthcare directive. We didn't really go over that. An advanced healthcare directive, people don't really like to talk about this. It's called a do not resuscitate. Let's say you do not want to go on life support. If you're in the hospital, you can craft that as part of your living will documents. I include that at no extra charge. It's really depending on if you want that or not. Also, reminds me, very important, I put in my wills that no autopsy or embalming should be performed on my body after I pass away, in keeping with the Islamic faith. I put that in the wills as well. I put in that, the burial, you should be facing Makkah, where the janazah should be performed, wudu should be performed, who's going to wash the body. All of those things will go into the will as well. And for the trusts are more complicated. So a trust will be, depending on how complicated it is, it'll be between $1,500 and $2,000. And that'll also include one property transfer as well into your trust. So that'll include the conveyance documents, the deed, affidavit of title, affidavit of consideration that you have to draft to transfer one property into the trust. If you have multiple properties, of course, I'm not going to, usually for quitclaim deeds, I charge $600. If you have a lot of properties, we can talk, of course, we can create a discount. If you have numerous properties you need to fund into your trust, I'm not going to charge you that much, but one property is included with your trust as well. Yes, sir?
So, we have to have will as well as trust if we have money.
It depends, right? Because there's certain things you might not want to put into your trust. You might just want to keep it as a will. Technically, with the trust, though, you can make it that it'll contain all the provisions for your will. However, let's say you want to designate burial procedures, you want to designate a guardian, you want to designate a trustee. You might want to also have a will and a trust in place as well. I do offer discounts for that as well. So if you want a will and a trust, let's say you have a very basic trust, I can do a trust and a will for $1,750. If it's either $1,750 or $2,250, depending on how complicated it is, and that'll include a realty transfer as well into the trust.
What do you call complicated? What is complicated?
A complicated will is, let's say, both your parents are alive, your spouse is alive, and you have a lot of children. If you have a lot of children, if you have a lot of beneficiaries, that is more of a complicated will. And let's say, sometimes people want to do specific things with their trust and their wills, like they might want to have their assets, instead of being distributed, they might want to have it invested. And then the money coming out of those assets, you want to think about how I want to deal with the income coming in. I want these assets invested, I want income coming in from these assets, and then I want that income distributed. Then you want to have to make sure that the income coming from those assets are also, you're paying tax for that because you don't want to get your beneficiaries in trouble. So that's basically when it comes into complicated or simple. Yes, sir?
You have a will and trust that was created outside of the state of New Jersey within the United States. Since relocated, do you need to do any kind of conversion, treatment? Does that still hold good?
It depends. In New Jersey, as long as you have the original, it's in writing, you signed it, and 2 witnesses signed it, it'll be good in New Jersey. And then, however, if you want to speed up the probate process and you want a self-authenticating document to avoid probate, just do that document over again in New Jersey and have either a New Jersey attorney or a New Jersey notary public sign that for you. But otherwise, as long as you have the 2 witnesses sign and you sign, it'll be valid here.
changes can happen in New Jersey, or only can the attorney?
No, you can make the changes in New Jersey as well. Let's say you want to make changes to your will, you'll draft a codicil, which we went over, and you can have that signed in New Jersey, and that'll be valid as well. Yes, sir?
I'm assuming that these wills and the trust they have nexus in the U.S., right? So I'm just thinking about if you have foreign assets or something, can they be brought under these two different modes of inheritance, like wills or trust, or you need to have a separate process for that outside the U.S.?
So that gets a little bit more complicated. Your will cover those assets, and it depends on the country you're from. So let's say, I know many Islamic countries, they already have, the government should be dividing it according to Islam as well there. So you can think about, you can do, all right, well, my property in Pakistan, that's gonna go to my heirs, according to the Sharia, and then I wanna make sure my assets here are also being split according to the Sharia. However, you're going to want to make sure you have somebody in Pakistan. You might want to have a successor executor named for Pakistan as well, because they're going to have to go to Pakistan, file that. Sometimes it's a headache though, because you have to prove if you're living in America that I am this person's heir. Talk to somebody who's had parents pass away in Pakistan, what they have to go through. They're going to have documents signed here from the consulate. You're going to have to say, oh, I'm this person's heir. You're going to have to do fingerprinting, send those documents to Pakistan, find an attorney in Pakistan, and then basically transfer those documents over. It can become a headache, but you definitely want to make sure, talk to an attorney in Pakistan, and then talk to an attorney here about how best to handle that. Sometimes in estate planning, you also want to think about that I have these assets. Maybe I want to do something with them while I'm alive. Like let's say, sell property I have overseas, invest that here. Or even if you have property here, let's say if you plan on going on Medicaid and you want to protect those, maybe I want to transfer that over to my heirs before I die. And especially if you plan on going on Medicaid, you definitely have to do that. There's many things you can do. Maybe I want to put this into an investment account. Maybe I want to put this into income producing property. When you have money like that, you want to be thinking about what's the best use of this money. Is it being used best sitting in an asset overseas? Or can you take that value and then make more value from that by doing something else? Yes, sir?
I don't know if you covered revocable and irrevocable trust. And my question was like, how long it takes to get effective? Let's say you do it today, how many years? And as far as irrevocable trust, how does it work? Like the creditors or any lawsuits, something comes up.
Sure. So
How long, what's the period after that? Those creditors or the lawsuit, they cannot come once you put all your assets in that irrevocable trust.
So an irrevocable trust will afford you more protection against.
Advantage in both. I mean, difference and advantage.
Sure. So a revocable trust and an irrevocable trust. The irrevocable trust, you can't take the assets out of that trust. Once it's in the trust, it's in the trust. You can't take it out of the trust. It'll give like really good protection against creditors, things like that. I really don't advise it because I think it leads to a headache down the line. Create a revocable trust, living revocable trust, so that assets, you can put assets into it, you can take assets out of it. Because let's say you have an asset you put into your trust, what if you want to sell it while you're alive? What if you want to retire and move down to Texas and Houston and enjoy the nice weather there? That'll allow you to do that, take the money out, spend it, buy a house there. Once an asset is in irrevocable trust, you're not going to be able to take that out. And as far as creditors go, I mean, listen guys, Islamically, once you pass away, Islamically, your debts should be paid out of your assets. That's really what needs to happen. So you guys should be thinking about that. It'll still afford your beneficiaries protection though against your creditors because it's not considered part of your estate. It's passing over to your beneficiaries while you sign the trust, right? So once you draft a trust, there's no waiting period. The only thing you need to wait for is when you fund the trust with your assets. So when you draft a deed transferring over to that trust, at that moment, your heirs will have their interest in it already. It's just that their interest in that property is, this is a fancy legal word, is a future interest conditioned precedent upon your passing away. So you won't have to wait years or anything like that. As far as creditors go, in general knowledge, usually they have around 6 years to press a claim. Sometimes it's different according to different, claims and things like that, but generally somebody has, and this goes across the board. If somebody owes you money and you need to sue them, you got to do it within 6 years of knowing. If somebody breaches a contract, you got to do it within 6 years. Otherwise, they're not going to be able to pass that through the courts.
The legal ones like sometimes the Medicaid or the medical bills, when those people they hold and your years, takes a long time for them to get the funds distribution.
Mhm.
But with the irrevocable trust, it could be that they cannot, that it get divided by without those creditors, is that right?
So technically, with the revocable trust, there's not going to be money left over for typical medical bills for those to be paid. You should pay them though, just for your own peace of mind. What would happen is you want to put into your trust that I want, everybody has their interest, but I want my burial expenses paid first. Unless people, the beneficiaries want to choose to pay, your parents' funeral expenses, you can choose to do that. It create a conflict though. Let's say the oldest brother pays the burial expenses, the estate is divided, how it's divided, then he says, hey, I paid these burial expenses, it came out before it's divided, I'm not getting reimbursed for that. Why did I have to pay it? Why shouldn't everybody else have to pay for that? That's why I advise you want to make sure that whatever is happening, have those judgments, have those collections, those debts paid out first. The revocable trust, I advise the irrevocable trust, you can avoid that, but it's hard though, because I feel like in life I see a lot of people, they get older and then they want to change their mind. They need money and their kids get married and they don't want their parents moving in with them, and they, our parents came from another land where it was different, right? Parents live with their children and they expect that coming from their children as well, and then kids get married here, it's a modern era, they don't want to do that, they don't want to take care of their parents, and they're like, all right, well, I already put this into a irrevocable trust, what am I supposed to do? That's why I advise, for all elders, you need to make sure you're looking out for yourselves as well. Because it's not easy in this country for elders. It's really not easy. So you want to make sure you have enough money to live right now. That's why sometimes I advise, have these mechanisms instead of giving this wealth away while you're alive. You don't know what's going to happen, right? What if, God forbid, you have a disease and you have significant medical bills while you're alive, and you need to pay those to have further medical procedures done. You want to make sure that you have those assets you worked for in case you need to sell those assets, you need to liquidate those assets to take care of yourself. So you have freedom, right? You don't have to depend on anybody else. You have the freedom, this is my house, I'll live here, I'll be protected. If I need to sell this house, move into a smaller house, I can do so. That's why I always advise have the living revocable trust over the irrevocable trust. Yes, sir?
Can you give us an example maybe? I'm thinking about how are the physical assets divided from an Islamic perspective? Like, at the time of execution, does the house needs to be sold off and then the money distributed? If it's a family, say the husband dies and the wife and two kids are left. How, could you walk me through an example?
Absolutely, excellent question, because people have many different type of assets, right? Let's say a mother might have her house, then she has jewelry, a car, bank account, safety deposit box. So that's why, again, I advise make sure your executor is not somebody who's inheriting, because it's going to lead to conflict when these assets get divided. Have a third party, maybe have a lawyer do this, but you want to think about it as well. Many times women, they want to leave certain jewelry to their daughters, and they should do that. So create a list of all your assets while you're alive, and of course it's going to change, the value is going to change, but just to have an estimate that your executor can go off of, this is worth roughly this much, right? And figure out how much your total estate is worth, how much value each person is going to get, and then divide it. Be like, all right, well, each person is entitled to $10,000, right? And my two daughters entitled to $10,000 each. My son is entitled to $20,000. You have some jewelry, you put the value, all right, well, I want my daughters to get these pieces of jewelry. That value will come from that. And then there's numerous things you can do. You can sell the house and split the proceeds, how they're supposed to be divided to fulfill that. Excuse me. I have kids in daycare, so I'm coughing like all the time. I apologize. You might also want to change the deed on your house after you pass away and tell your executor, listen, I want all these people to have an interest in my house. Then they can choose to do what they want to do with it, right? So a mother can say, well, I want my house is going to be split into fourths. Each daughter is going to get a fourth and my son is going to get a half, right? And the ownership, it will be like that on the affidavit of title. Then they can choose to sell the house, not sell the house, keep the value. They all want to live in there. But essentially, you want your beneficiaries to enjoy your estate as well. So that's why I usually don't like having multiple people on the deed, because let's say, all right, one person says, well, I want to live in here, and it's not big enough for all our families. What are we going to do about that? Just wait till I pass away and you get your interest. I don't think that's right, and I don't think that's right Islamically either. So maybe you want to put into your will, I want this sold, or let's say each person gets their interest in this house, but the mother gets to stay in this house as long as she's alive. That's another big concern about people. My spouse is only inheriting 1/8 of my estate. What's going to happen to her? Who's going to take care of her? Where is she going to live? You could put it into your estate. Listen, everybody's going to get their interest in the house, but as long as my wife is alive, she's going to be able to stay in this house. You have the value. You guys have to take care of her. If she chooses to sell the house and split the proceeds, that's okay, but she's going to have that decision-making power. And I think that protects many people in these type of situations. That's a common concern people have. You can also do something completely different and say each person has their interest in the house. Everybody's going to leave the house. I'm going to put this house up for rent, and then everybody's going to get, the rent is going to be split according to the ratios, and everybody's going to get their money from the rent as well. You can do it like that too. Yes, sir?
Do you have to register wills and trust in the county office?
No. So your will is a public document. You register it after you pass away. Technically, you can register it while you're alive, and they'll hold it for you. Just pay a small fee. I honestly think this really does nothing other than the government getting a small fee from you. It's not going to speed up the probate process. It could, if you need a safe place to keep your will, the original will, you can choose to do that, but let your executor know like how to get it. I advise people, keep your will in a safe place. The trust, you never have to register with the government. The government stays out of it. Keep the original copy of your will, right? Original, make sure each one of your executors knows exactly where it is and they have access to it, right? Now this might be, you might have it in a drawer in your house, let the executor know it's going to be here. You might even want to give the original to the executor. And then, maybe sign multiple originals, give one to another executor. Like that. Yes?
There's some online questions. I just texted them to you.
Oh, okay. Let's see. Okay, so online question number 1. Why would Medicare go after your assets? Is it because you're owed money to them? So it's not Medicare, it's Medicaid. Medicaid and Medicare are different, right? Medicaid, we have Medicaid programs in New Jersey like NJ Family Care. There's numerous other programs. And Medicaid is a good way for people who need services from the government that might not be able to afford them, like health care, like, we have a lot of Muslim adult daycares here. That's all run through Medicaid, right? You think, oh, my parents aren't paying for anything for this. Somebody's paying. I guarantee you somebody is paying for those services. It's the government paying for those services, and they're keeping track of every single penny they spend. And when you sign up for Medicaid benefits, in the fine print, it says you're allowing them to go after your estate to receive these benefits. I had a very close personal friend of mine. His father was on NJ Family Care. He got COVID, was in the hospital on a ventilator for a month, had open heart surgery done, and then passed away. My friend thought him and his sister were inheriting their father's house, and then they got a call from Medicaid saying, no, you need to pay us. And if you don't pay them out of your estate, they'll put a lien on your house. And what will happen is when they go to sell that house, Medicaid is going to have a priority lien. Medicaid is going to have to get paid first. So if you're over the age of 55 and intend on taking Medicaid benefits, this is a situation where you want to transfer your assets to your heirs beforehand, right? Because even once you go on Medicaid and you transfer your assets, they're going to be like, no, no, no. There's only two situations where that's possible. Either once you're on Medicaid, within 1 year, well, for the child, within 2 years, if you transfer it to that child, it'll be fine. But that child, before you went on Medicaid, would have had to been your primary caretaker, also living in that house and having that as their primary residence. You can also, a sibling can do this as well, but the sibling that would have to be transferred within 1 year, and your sibling would have to be your primary caretaker and then living in that house as well for you to be able to transfer it once you get on Medicaid. I have another online question. Can we include bank accounts in a trust? Absolutely you can. It's a simple matter of contacting your bank. They're going to send you a form, and the ownership of your account is going to go from Arij Sayed to the trust of Arij Sayed. Very simple to do. Yes, sir? They don't have to be Muslim. I would advise, though, if you are a Muslim, pick a Muslim as your executor because they're going to understand it and they're going to care about making sure everything is divided according to the Sharia specifically, but they don't have to be Muslim. Many times people choose to elect attorneys as their executors as well because sometimes it can get a little bit, complicated. The executor doesn't have to be a Muslim.
Can the executor be his spouse or the child?
So I really advise against that. They can be your spouse and children, and that's the first thing we'd think of, right? Our executor, I'm gonna make my wife my executor. I'm gonna make my oldest son my executor. He'll handle my affairs. But I advise against this for two very important reasons. One is you don't want your grieving spouse and your grieving children to have to deal with this at the time of your death, right? They're already going through enough trauma. To deal with the complicated legal process is gonna be a burden. But most importantly is to avoid a conflict of interest for your beneficiaries. I know you've all probably have heard horror stories of, children competing against each other, getting into fights, saying, no, I want this asset, I want this asset, I want to live in the house, no, I want the household and I need money from it. And then the person who has the power to do so, the other people are going to get mad at them and it's going to create division. So when you have the chance to do this, avoid this. Of course, there are going to be certain situations for certain families where that's not possible, right? They don't have somebody who's willing to be their executor. In which case I'd advise, okay, maybe have a brother be your executor or a sister, because technically they're not direct beneficiaries. They possibly could be indirect. They might inherit if there's a residuary, if there's something left, that's fine. But other than that, some people choose to do so because they don't have anybody. But if you have somebody to be your executor, choose them. And I think this is an important point for all of us. Listen, we're all here in this country as Muslims. We don't have anybody else to rely on. We need to rely on each other. We need to make sure that if my friend passes away, I'm willing to be his executor, right? And then if you pass away, you need to make sure you have friends that are willing to be there for you and your family to be that executor and to do that job. And we shouldn't ask for compensation for this, because if we can't be somebody else's executor, why should we expect somebody to be our executor? We're one ummah, we're one community, we're brothers and sisters, and we need to make sure we're willing to be there for each other to accomplish this for each other. Because otherwise, the state's going to get involved, and this is going to be in the hands of the kuffar, and that's something we do not want to happen. Yes, sir? Cost to maintain the trust. It depends, right? If you have trustees, let's say you have close friends or people willing to be the trustees without cost, there shouldn't really be any cost to maintain that trust. But let's say down the line, it's possible that there could be cost, right? Because let's say down the line, you can't find anybody to be your trustee. You might have to tell somebody, all right, listen, be my trustee and I'll compensate you for it. And you can put that into the trust as well, that they're allowed reasonable compensation. You could put in the amount, be like, all right, it'll be $200 an hour. They have to, itemize their work, and then the beneficiaries will have to pay them out of that. It could be the beneficiaries can choose to do that and set the rate, in which case, yeah, there could be cost. But if we're willing to be trustees and executors for each other, I believe, listen, we should do this for our brothers and our sisters without any cost. Unfortunately, we live in a society where people care about themselves and their family, and that's it. But we really need to think about this because we don't have the government here to have our back to ensure that our estate is divided according to Sharia. We shouldn't have to pay somebody to be our trustee, but unfortunately, that could be a reality we face. Any other questions? Yes, sir? So if, excuse me, if somebody doesn't have any heirs, it gets complicated. I can discuss that with people, in private to discuss what would happen. Generally, you can bequeath up to 1/3. After that, if you, listen, you might not even think of some heirs that you have. It can get deep, right? You can find like nieces, nephews. Let's say you don't have any parents, but your grandparent is alive. They're supposed to inherit if your parent is not alive. There's a whole chain and there's extensive scholarly work written on this. So without giving you an answer, I would need to see, what the exact circumstances are and then do the research as to what would happen. In many circumstances, you will be able to find an heir. Yes, sir?
It's mirror wills, like husband and wife have the same, they're parents of the same kids, and they have most of the time they have same asset. So is there any mirror will you can have for both of them?
Certain states might have that. In the state of New Jersey, you need to have your own will. And I'd always also advise Islamically because the division is going to be different between you and your wife because technically you're entitled to more of your wife's estate than she's entitled to your estate. And then in the state of New Jersey, you need to have your own will as it is. Any questions from the sister's side? All right, well, I think that's it. Thank you so much for your time, everyone. If you have any questions, feel free to call me, text me at this number. My website is aritsayedlaw.com, also theprincetonlawyer.law.com. I have a free ebook on my website as well, aritsayedlaw.com/resources. It basically explains different estate terms, different legal terms, what they mean in the estate process. I also have some pens outside, some business cards, a flyer. Please feel free to take and tell your friends. And if anyone, most importantly, we have refreshments outside. I know I threw a lot of information at you, so please, let's have some refreshments, get our energy back before Isha. And if anybody has any questions at any time, always feel free to contact me. Thank you so much. My voice is a little hoarse.
Would I be able to, Shazam, bring my current will that I already have, but it was done when my kids were minors, now they're not. Is that something you would update? Is that a codicil?
Yeah, that's a codicil, absolutely.
And then create a trust?
Yeah.
Right? That would be that package that you're speaking of? An updating current one.
Honestly, that's a codicil. When I create a trust, I'll update the codicil. It's not a complicated document.
Okay. Yeah, because I definitely need a trust, but I still don't understand the 1/8, 1/4. That's the IO.
It's complicated. There's a lot of math involved
Yeah.
too.
So
For everybody with all the fractions.
understood. Is that like an hour session or how long is it?
So what I typically do is you can have an initial consultation over the phone or through Zoom. I'll send you an intake form with any questions